o'clock, and our agenda is mostly the verbal presentation on the National Environmental Management Laws Amendment Bill, and we will be receiving presentations by the Centre of Environmental Rights, as well as the Department of Environmental Affairs and Development Planning from the Western Cape. Then we will be able to move over to resolutions or actions from the committee side, and you will also be asked to consider and adopt the draft minutes of our last meeting, which was held on the 28th of July. So members, I'm just quickly going to give you an opportunity to introduce yourselves. I'm the chair of this committee, Andrikus van der Westhuizen, and if the other members could just quickly introduce themselves, and then we'll go over to our guests. Thank you.
Deirdre Baartman, chairperson.
Thank you, Honourable Baartman. Honourable Heron.
Brett Heron.
Is Honourable Maseko also in the meeting, or is she still joining? Okay, I think I hear her coming down the stairs. Hopefully she will be able to join us soon. And then if I could first give an opportunity to our guests that don't engage with us that often, and those are the representatives from the Centre of Environmental Rights. Who's going to go first and introduce yourself?
Hello, my name is Danielle Midgley. I'm at the Centre for Environmental Rights. I'm the environmental law specialist. And sorry, I'm just going to turn that off for a second. Yes, so as environmental law specialist, one of my duties is to monitor parliamentary developments in the environmental space and to facilitate commenting. So I've also previously offered environmental law training workshops to members of Parliament in the 3 environmentally related portfolio committees. And myself and 2 colleagues will be presenting our comments today. I'll hand over to my colleague Teresa to introduce herself.
Thank you so much.
Good afternoon, and thank you for the opportunity. My name is Teresa Mugunyani. I am an attorney at the Centre for Environmental Rights in the Mining Department.
Thank you very much and most welcome. And the last member of your delegation?
Hi. Good afternoon. My name is Nicole Loza. I am an attorney in the Pollution and Climate Change Program at the Centre for Environmental Rights. Thank you for the opportunity to present to you today. It's good to be here.
It's good for us to have you, and thank you very much. I hope you will feel welcome. I'm just quickly going to give others an opportunity to also introduce themselves, and then we will go straight to your presentation. Can I just ask, I was informed that the South African Local Government Association would also be sending a representative. Not yet. And then can we go over to the National Department of Environment, Forestry and Fisheries? Can we start with Ms. Garner?
Hi, good afternoon. My name is actually Frances Craigie. I am standing in for Linda Garlip. I'm the Chief Director for Enforcement from the department. And I thought maybe it would be a good idea if you wouldn't mind, Chair, for me just to introduce our team. There are quite a lot of them on the call, but I can introduce them. Thank you very much.
And we feel honored by sending such a strong delegation to the Western Cape. Thank you.
Thank you. So we have Amanda van Rienen. We have Anbin Kile, we have Machtel Boshoff, we have Michelle Gavender, we have Vumile Seneni, Dr. D. Fisher, Dr. Mpochi Tingoni, and they deal with a whole range of different items from waste through to biodiversity, through to air quality and EIA issues. So I think you've got the whole team from National also here to listen to the comments from those parties that will be presenting today.
And thank you very much. You may have to introduce some of your members if they're going to respond later on again, but you're
sure, I'll do that.
Most welcome. Good.
Thank you.
And then can I go over to our the people that we engage more often with, and that is the Department of Environmental Affairs and Development Planning of the Western Cape. And I don't know, is Mr. Mohammed going to go first?
Yes, Chair, thank you very much. Ayub Mohammed, from the Chief Director Environmental Governance from the DA and DP. And with me, apologies firstly on behalf of my HOD, Mr. Piet van Zyl. He's not able to make the meeting. And then I've got Anika Rousseau and Mr. Paul Hardcastle. And Mrs. Marlene Laros, they are the representatives from the Department of Environmental Affairs and Development Planning. Thank you.
Thank you very much. And who will be doing the presentation later?
Between Anika Rousseau and Paul Hardcastle, they'll be doing the presentation.
Good. Thank you very much for that, Mr. Mohammed. And then is the Department of the Premier also represented in this meeting? Not so. Thank you.
Good afternoon.
Oh, sorry. Seems to me I was too quick. Is Ms. Mellem in the meeting?
She is in the meeting, Chair.
Good afternoon. It's Michelle Mellem. I'm the legal advice, state law legal advisor in the branch legal services department of the Premier. I assisted the Provincial Department of Environmental Affairs with a collation of their comments. Good afternoon.
Thank you, and most welcome to you as well. And then I believe it could be the Provincial Parliament legal advisor. I think I saw the name of Mr. Andre Leroux coming up on my screen. Are you still in the meeting, sir?
Hi, good day, everybody. My name is Andre Leroux. As the chairperson indicated, I'm the legal advisor for the Western Cape Provincial Parliament.
Thank you, and most welcome, advocate. We will most probably be making use and asking you some questions going forward, because this seems to be quite a complex piece of legislation for people that don't work with this every day. Thank you very much. Can I just ask, are there any other people that would like to introduce themselves that I haven't covered yet?
Chairperson, it's Chantal from SALGA.
Okay, good. Thank you. So we do have our SALGA representative, Chantal Harigubin. How do you pronounce that?
It's Harry Gobin, that's correct. And we also have two other colleagues, Mr. Armstrong Mpelo and Mr. Luiso Njimela.
Thank you very much, and most welcome our representatives from SALGA. Good. Honourable members, thank you. I see that you are all already on mute, and I appreciate that. Just before the meeting started, there was a bit of background noise. It seems as if somebody was very close to a motorcyclist, and it does make things just so much easier, and for each and everyone, if we keep our microphones on mute, except obviously when we are participating in the meeting. So thank you for that. Please, those of you that do have the hand raise function on your computers, we are such a big meeting that I don't have the full list on my screen of all the participants all the time, but please use that, and hopefully I will be able to recognize you if you want to take part in the meeting. And then also, please note that this meeting is being live streamed by the ICT staff of the Western Cape Provincial Parliament, and we therefore also welcome our viewers that are not able to participate actively, but that also showing an interest in this important legislation regarding the environment. And then should any of you at any stage struggle to be reconnected, then please don't hesitate to contact any of our ICT staff. Some of them might even just in the chat box quickly give you contact details, email or so, where you would be able to get assistance from. And then please unfortunately, due to the limitations of the Microsoft Teams system, we do not have interpretation services, and therefore it would be appreciated if you could conduct the conversation and the presentations in English. Then just one person that's been quiet, but who is really working very, very hard and making this possible is our procedural officer, Ms. Shireen Nikerk, and I would like to acknowledge also her presence and thank her for uploading various documents onto the MS Teams folder. And honorable members, you will also see there quite a big document where she listed clause by clause the clauses of the amendment bill, and also summarized the written submissions that refer to specific clauses in that document. And this has been quite a daunting task, but I think it will help us tremendously in considering the various clauses going forward. Please, members, feel free to contact her. I had to contact her to get to that document, although she then pointed out to me that it was also emailed to me yesterday. Now, the amendment bill was referred to the committee on the 19th of November already last year, and the NCOP Select Committee on Land Reform, Environment, Mineral Resources and Energy provided us with a program for the processing of the amendment bill in December of last year, but then a revised program was received from the Select Committee, and we now have quite a lot of time to respond to this piece of legislation, and we will be coming back to that just now. Now, the members of this committee was also invited to the briefing that some of the members in this meeting also did when they briefed all provinces on the 9th of June regarding this bill. And I want to thank them for that introduction and for putting us on the path in the way that they did. We as a committee then decided on the public participation process that we would follow. And in terms of public engagement, we agreed that this process would entail at least one virtual public meeting, which is the one that we have here today. And advertisements were placed in all the major print media, as well as on the social media of the Western Cape Provincial Parliament. And we received a number of written submissions, but then also a request for the 2 oral submissions that we are going to have here today. So the one oral submission would then be from the Centre of Environmental Rights, and one from the Department of Environmental Affairs and Development Planning. And hence the reason for our meeting here today. Good. So without, well, perhaps I could just quickly ask honourable members, are there any questions before I allow our guests to start with their presentation? Any questions regarding the process this far? None? Thank you. So then if our guests from the Centre for Environmental Rights are ready, perhaps Ms. Midgley, you would like to beam your presentation, because thank you. We've also received a presentation earlier today, which was also uploaded into the Teams folder for those of us that would like to come and would like to go and refer back to it. And so, Ms. Midgley, it seems to me you are going to kick off, and you are most welcome. We are all ears for what you would like to share with us.
Thank you so much for that introduction. Can you see my slides, and can you hear me all right?
Fantastic. Everything is 100% on my side, and I trust the other members would be able to see it as well.
Wonderful. Honourable members, thank you for this opportunity to address the Standing Committee with our comments on this version of the National Environmental Management Laws Amendment Bill. I will introduce the Centre for Environmental Rights, myself and my colleagues presenting today. I'll only be presenting one of our substantive comments, and then I'll hand over to my colleagues. Today, we are presenting our priority submissions taken from the 3 documents that I've sent to your procedural officer, Shireen. However, I do hope that you take all of our comments in the documents into account. These are comments which we prepared earlier this year for the NCOP's participation process in January and which have not yet been addressed. The bill has not changed since then. It's still the 14D version. So the Centre for Environmental Rights is a non-profit organization and law clinic based in Cape Town and Joburg. We are activist lawyers who help communities and civil society organizations in South Africa realize our constitutional right to a healthy environment by advocating and litigating for environmental justice. And we are turning 10 years old this year. Our attorneys have a wealth of practical experience in applying the laws, which this bill seeks to amend, and we have submitted comments on earlier versions of this bill. You've seen our faces, but I'll just briefly introduce ourselves again. I'm Danielle Midgley. I'm the environmental law specialist, and one of my duties is to monitor environmental developments in Parliament and to facilitate commenting on draft legislation. And I've also previously offered the environmental law training workshops to members of Parliament in the 3 environmentally related portfolio committees. My colleague Teresa Mugunyani is an attorney in our mining program, and she has experience working with communities on issues relating to land tenure, evictions, housing, and the environmental rights of mine hosting and mine affected communities. And my other colleague, Nicole Losa, is a senior attorney in the Centre's Pollution and Climate Change program with extensive experience in air quality, climate change, and pollution litigation and legislation. I had a look at your provincial parliament's core values on your website, which include recognizing, valuing, and embracing diversity as a strength in performing our functions, as well as respect for the dignity of others and the duty to act with kindness, tolerance, and appreciation of diversity. I was pleased to see that these core values, because I want to introduce our comments with a special emphasis on gender inequality in the environmental context. Black women, women from low-income communities, and women from the Global South bear an even heavier burden from the impacts of climate change because of the historic and continuing impacts of colonialism, racism, and inequality, and in many cases because they are more reliant upon natural resources for their survival and or live in areas that have poor infrastructure. The Centre for Environmental Rights is seeking to advance gender equity in our environmental justice work. And we hope that through your core values, you will take this into consideration and recognize this when considering legislation which regulates the environment that we all live in. I'm going to move on to my substantive comment now. It's a very technical comment regarding transitionary provisions, and it concerns these provisions before the one environmental system commenced. My comment starts on page 49 of our table of comments, in case you have those documents open in front of you. And it relates to clause 82 of the bill, which seeks to amend section 12 of the Amendment Act. So this comment relates to the interaction between the Environmental Impact Assessment under NEMA and environmental management tools under the Minerals and Petroleum Resources Development Act, MPRDA, which were approved prior to the environmental regime called the One Environmental System in 2014. So various authorizations are required under NEMA for mining, and various permits and rights are required under the MPRDA. This section seeks to remove the requirement for a NEMA authorization by saying that a particular permit, called an Environmental Management Program, that's EMPR, is deemed to be a NEMA authorization. At the Centre, we object to this because these acts have different objectives, and we argue that it is essential that processes under both should be conducted in order to determine if the environmental impacts of the proposed development or mine constitute ecologically sustainable development as required by Section 24 of the Constitution. We agree that uncertainty in Section 12 must be eliminated. However, we point out that the proposed amendments are ambiguously drafted and fail to eliminate the uncertainty. Even the bill's explanatory memorandum is ambiguous, and we've put in our comments in the table the reasons why it is ambiguous. We stress that we continue to oppose any move to deem MPRDA-approved environmental management programs and plans as environmental authorizations under NEMA. We do recognize that this is the intention of the proposed amendments, but we reiterate that this still remains ambiguous in the current wording of the amendment bill. Our objection is that such deeming will entrench old order environmental programs and plans that do not comply with the provisions of NEMA and inappropriately blur the distinction between environmental impact assessment and environmental management. I've just got 3 more sentences explaining this blurring of the distinction, and then I'm going to hand over to my colleague. So we believe it is inappropriate to equate environmental management plans and programs approved under the MPRDA with environmental impact assessments conducted in terms of NEMA. The NEMA Integrated Environmental Management System was always a necessary supplement to the EMPR regime under the MPRDA. The range of information that must be considered by decision makers under the NEMA system is much wider than that under the MPRDA. The NEMA Integrated Environmental Management System requires decision makers to take into account provisions of specific environmental management acts, guidelines, policies, and various environmental management instruments. Under the MPRDA, the Department of Mineral Resources notoriously approves EMPRs and EMPs without taking these into account. NEMA also has more detailed provisions relating to public participation process and contains more effective and clearer remedies for non-compliance. The proposed amendment, therefore, has the effect of lowering the standard of the ongoing environmental management of extractive operations approved before or on the 8th of December 2014. In addition, NEMA requires that environmental impact assessments are prepared by independent environmental assessment practitioners, whereas the MPRDA has no such requirement. And this means that many approved EMPRs and EMPs were prepared in-house by the applicants for those rights. I'm going to hand over now to my colleague Teresa, who will take you through our submissions on NEMA and the Protected Areas Act. And of course, we'll be available for questions at the end for the discussion. So thank you very much.
Thank you, Danielle. And thank you once again for giving us the opportunity to present our submissions. Due to time constraints, I will focus on some of the specific amendments in the NEMA and the NEMPA. The intention behind the NEMA, which is at the core value of our work, is to ensure that environmental management places people and their needs at the forefront, put people and their needs at the forefront of its concern and serve their physical, psychological, developmental, cultural, and social interests equitably, and further development must be socially, environmentally, and economically sustainable. In looking at Section 24G of the NEMA, our initial submission is that Section 24 provides for consequences of unlawful commencement of listed activities. We note that currently there is no provision to enable a person who has undertaken ownership or control of property on which an unlawful structure or development has been built to have such structure or development legalized. This clause aims to amend Section 24G of the NEMA to allow a successor in title or person in control of the land to lodge a Section 24G application. We have been a long critic of Section 24G because we regard this section as a provision that undermines various environmental management principles as set out in Section 2 of NEMA. And we of the belief that this section allows developers to buy themselves out of the criminal and civil consequences of non-compliance with NEMA. We are of the view that Section 24G should be done away with, as we are of the belief that it continues to perpetuate and to allow individuals to operate as an incentive and commence without environmental authorizations. We view it as that people see it as a simpler and faster way to allow for acts to continue without environmental authorization. Should there continue to be Section 24G, we propose that Section 24G be amended and the regulations relating to the procedure to be followed and criteria to be considered when determining an appropriate fine to be amended. We request for an amendment of the fine. Currently, it sits at 5 million. In many cases, we consider such a fine too low to constitute proper disincentive for illegal activity. We have witnessed the abuse of Section 24G process by environmental assessment practitioners who continue to refuse to provide access to Section 24G application forms, and we call for and accept that there should be public participation that is allowed. Currently, we note that and we argue that the refusal that is given sometimes with regards to the application of Section 24G, where there is a refusal to provide public participation information to affected parties, affect how this section is implemented. We argue that this refusal undermines effective public participation that is called for in PAJA and NEMA principles. This approach also results in the continued abuse of Section 24G, as it is perceived as a quicker and cheaper alternative to obtaining environmental authorization before the commencement of listed activities. Our submission is for a call for the public participation process to be open to allow affected communities to participate, and secondly, for an increase of the fine from 5 million to 10 million. We note that as CER, we have done extensive work on administrative penalties and have argued for an increase in the fine fee. We continue to advocate for a proper system of administrative penalties in South Africa's environmental law. We can make access to the work that we have published and the investigation and the research that we have done, should this be needed in your consideration, and this can be done after this presentation. I'll continue to look at Section 43. Section 43 of the NEMA, as it currently reads, allows a person to appeal against an environmental decision issued by national or provincial departments responsible for environmental affairs. Section 43 offers amendments in 4 different sections, which is Section 43(1)(c), Section 43(7), Section 43(8), and Section 43(9). In looking at Section 43(1)(c), we understand this as the intention of this proposed amendment is to bring all appeals of decisions made by municipal licensing authorities in terms of the NEMAQA under NEMA. The current position as per Regulation 3.3 of the National Appeal Regulations Act is that an appeal against a decision by an official or municipal manager acting under delegated authority from a metropolitan district or local municipality must be submitted, processed, and considered in terms of Section 62 of the Local Government Municipal Systems Act 2000. This position has created challenges and limitations for interested and affected parties wishing to participate in appeals, as the effectiveness of participation is limited. The enhancement or the allowance that is now given by Section 43 and Section 43(7) to consider local authorities as allowing appeal processes is accepted. Section 43(7), an appeal under the section suspends an environmental authorization exemption or any other decision made in terms of this act or any other specific environmental act or any provision except for a directive or other administrative enforcement notice that is aimed at addressing significant harm to the environment issued in terms of the act. We support this proposed amendment and agree that it is inappropriate for directives and compliance notices issued in terms of NEMA to be suspended pending the outcome of appeals against those directives or notices. We note that in most instances, directives and compliance notices must often be immediately effected for them to be effective, especially when the activities that are subject to directives or compliance notices can cause significant and irreversible harm to the environment. In terms of the proposal to Section 43.8, we note and accept the proposal. We ask that there be an inclusion of the executive committee and executive mayor be directly mentioned. We note that insofar as appeals or directives issued by municipal manager or his delegate are concerned, the proposed amendment to Section 43.8 only contemplates appeals to the municipal council and not to the other municipal appeal authorities identified above in the proposed amendment to Section 43.1c. We note this as an oversight and request that the specific mention of executive mayor or executive committee be included. We then move on to Section 43.9, which proposes to lift the automatic suspension of licenses pending outcomes of an appeal. We vigorously oppose this proposed amendment. Based on our experience and expertise, it will always be inappropriate, pending the outcome of an appeal, to uplift the suspension of a decision contemplated in proposed subsection. In our experience, the relevant minister always exercises his or her discretion to uplift the suspension, irrespective of the potential impact on any affected area, and always grants circumstances favoring the suspension. We also note in our experience that the possibility of irreparable environmental harm from the licensed activity pending the outcome of appeal is never considered, despite the fact that the statutory discretion of the minister to uplift the suspension must be understood and exercised in the context and objects of the NEMA principles. Uplifting a suspension of an environmental authorization under appeal is effectively dismissing the appeal without considering the merits of that appeal. We note that continuation of and adoption of this principle will prejudice any applicant that may suffer as a result of suspension. I will continue to then look at the NIMPA. Section 48(1)(b) allows commercial mining in a protected environment, provided the minister issues written permission. The clause further amends subsection 4 to provide for the criteria under which the written permission contemplated in section 48(1)(b) may be issued by the minister. The minister may require any further information that he or she may deem necessary before making the decision. We support the amendments and insertions. We submit, however, that it should be made explicit that the prohibition in subsection 1 includes directional drilling, underground mining, and related activities in protected areas. And these protected areas are mentioned in subsections A to C. We submit that underground drilling and mining can have significant environmental impacts on ecosystems, including the surface ecosystems. NIMPA must be explicit that underground drilling or mining in protected areas is prohibited to ensure the ecological integrity of those areas. We submit that the section should specify that ministerial consent under the section may only be given in exceptional circumstances, and not only may be given, but must only be given in exceptional circumstances. Given that many of South Africa's biodiversity hotspots, important ecological infrastructure, and strategic water source areas occur on private land, the declaration of a protected environment in respect of those areas is often the only available option to secure the ecological protection of those areas. I will give a practical example of a matter that we're currently assisting as the Center for Environmental Rights. In this matter, 8 civil society organizations are currently challenging the decisions by various organs of state to authorize mining in the Mabola protected environment near Vakastrom in the Mpumalanga province. The organizations opposing this particular mine do so because the proposed mine will be inside a declared protected area and a strategic water source area. If this mining proceeds, it will threaten water security, not only in the local area, but in the region. The damage that this mine will do to water resources cannot be undone. This is why it is important to ensure that there is a limitation that is given to when mining or prospecting can be allowed in protected areas. I will hand over the continuation of our presentation to my colleague, Nicole.
Thanks, Teresa. So I will be briefly talking through some of our comments on the Air Quality and the Waste Acts. And I would just like to again reiterate that much of the detail of our comments and submissions is in our written submission. So I strongly urge the committee to consider our written comments, as I won't be able to go through all of those comments today in this presentation, but they are still nevertheless very important. So just as some initial background and to provide some context for our comments in relation to the Air Quality Act, I would like to emphasize the serious public health crisis of air pollution in South Africa. The World Health Organization confirms that air pollution is the world's largest environmental health risk. A study by the Lancet finds that the number of deaths due to air pollution in 2015 was 3 times greater than the number due to AIDS, tuberculosis, and malaria combined. There is no dispute that air pollution in many parts of South Africa is above safe levels, with regular exceedances of our national ambient air quality standards. All of the evidence for heavily polluted areas, such as the Mpumalanga Highveld, shows that by far the bulk of the pollution is from industrial sources, including coal-fired power stations and mines. Eskom itself admits that the pollution from its facilities causes over 300 deaths annually. An independent 2017 study finds that the air pollution from Eskom's coal plants alone is responsible for 2,239 attributable deaths annually, and the cost is $2.3 billion every year. The National Air Quality Officer frequently concludes in her annual State of the Air report that many South Africans may be breathing air that is harmful to their health and well-being, especially in the priority areas. It has been nearly 13 years since the Highveld priority area was declared, and still there has been no meaningful improvement of the air pollution there. As a result, we, on behalf of Groundwork and the Vukani Environmental Justice Movement in Action, have had to institute constitutional litigation against the Minister of Environment and other government bodies, including the President, to call for action to improve the unacceptable air quality in the Highveld priority area. The people of South Africa have a constitutional right to an environment that is not harmful to their health or well-being. As such, addressing air pollution should be a priority. This is particularly the case in light of the COVID-19 pandemic, as people living with poor air quality are found to be more susceptible to this disease. It is clear that air quality management requires cooperative and prioritized governance, dedication of human and financial resources, and effective implementation and enforcement. So with that context in mind, I'll briefly address some of the proposed amendments to the Air Quality Act. I'll start with section 13.1 of the Act, which is clause 51 of the bill. The bill proposes making the establishment of a National Air Quality Advisory Committee discretionary. So we think that the establishment of this committee should be mandatory and not discretionary. It is currently mandatory, so we recommend that section 13 remains as is and the must remains in place. Such a committee has not yet been established, but it could and should play a vital role in addressing widespread non-compliance with air quality and emission standards and facilitating the proper implementation and enforcement of the various tools under the Air Quality Act. Then in relation to section 47A of the Air Quality Act, this is a new provision that's been inserted by the bill, and we welcome the addition of section 47A as it allows for licensing authorities to revoke and suspend emission licenses under certain circumstances. Our only concern is that the conditions for revoking or suspending a license are unduly restrictive and may hinder licensing authorities in effectively carrying out this power. So A license can be revoked or suspended if the licensing authority has evidence that the license holder has contravened a provision of the Act or a condition of the license, and such contravention may have or is having a significant detrimental effect on the environment, including health impacts. We submit that a contravention of the Act or a license alone should be sufficient for the suspension or revocation of an atmospheric emission license. A licensing authority should not have to overcome the additional hurdle of showing or having evidence that the contravention is also having or may have a significant detrimental effect on the environment, including health impacts. This not only sets the bar too high for suspending or revoking licenses where there's a non-compliance, but it would also be unduly onerous and burdensome on licensing authorities, particularly given capacity constraints of many licensing authorities, especially municipalities. So I will now move on to our comments in relation to the proposed amendments to the Waste Act. I'll focus specifically on the Part 8 contaminated land provisions of the Waste Act. So Part 8 of the Waste Act essentially provides for a process in terms of which land which may be contaminated must be assessed by the owner or person in control of the land. And if that land is found to be contaminated, it must be remediated in terms of the processes set out in Part 8 of the Act. And over the years, we've have a fair amount of experience in dealing with the implementation of Part 8 of the Waste Act. So our comments are very much informed by that experience. And for this presentation, I will speak mainly just about two broad and general concerns. The first being the need for enforceable timeframes within which site assessments must be conducted. And the second is the need for improved transparency and public notification in relation to land that may be or is contaminated. So in relation to the issue on timeframes, that pertains mainly to Section 37 of the Waste Act. There are no timeframes for conducting a site assessment report in terms of Section 37. This is problematic since we are talking about potentially significant contamination, which may be placing people's health and well-being and the environment at serious risk on a daily basis. The Act recognizes circumstances where urgent remediation may be required. And Section 37 states that the notice directing a site assessment to be conducted should specify a time period within which the assessment should be conducted, but it does not state what this time period should be. As an example, I'll just talk a bit about our experience in dealing with ArcelorMittal in relation to the remediation process followed for its ArcelorMittal's steel plant in Vanderbijl Park. Firstly, no time period was specified in ArcelorMittal's notice to conduct a site assessment. So it then took approximately 2.5 years for ArcelorMittal to submit its site assessment to the authorities. And this was with multiple follow-ups and pressure from us. So nearly 3 years after ArcelorMittal was notified to assess its land for contamination, it was found that the land was indeed contaminated, and the department has now issued a remediation order to AMSA. It does not make sense that a person could be permitted any number of years to undertake its site assessment merely to ascertain whether or not land is contaminated, particularly as the very objective of these provisions is to protect people and the environment from the effects of harmful contamination. We have recommended some additional amendments to Section 37. Specifically, we recommend that it should state that site assessments must be conducted within 90 days. And then onto the second broad concern in relation to Part 8 of the Waste Act, in relation to transparency. There needs to be improved transparency and express provision for publication and public notification in relation to contaminated land, particularly at the assessment and remediation stages. We see that this bill intends to amend Section 41 of the Act to do away with requiring investigation areas to be reflected on the National Contaminated Land Register. In other words, land that is suspected to be contaminated and is subject to a site assessment but has not yet been declared contaminated would not yet be reflected on the register. We advise against this because this information is of public importance. There must be a way for the public to ascertain potential risks as a result of potentially contaminated land even if that land has not yet been confirmed to be contaminated, because people must be able to take necessary precautions to track the process and progress of investigations and to hold those responsible to account. To use ArcelorMittal as an example again, we now know that the land at the Vanderbijl Park facility is contaminated. Yet, during the 3 years while the site assessment was being conducted, and even before that, the surrounding communities were provided with no information on this. Even now, ArcelorMittal is not voluntarily or automatically giving any access to information on the remediation process that is being followed. So, for these reasons, we recommend that the National Contaminated Land Register remain a register that reflects land that is under investigation, as well as land that is declared to be contaminated. Very importantly, the National Contaminated Land Register must be publicly available and accessible online on the department's website. Moreover, all the decisions, reports, and records that are produced through the Part 8 process, so for example, site assessment reports and remediation orders, must be automatically publicly available. That concludes our presentation today. Thank you so much for the opportunity to present to you, and please let us know if you have any questions for us.
Thank you very much, and thank you. I think it went well with your presentation. I'm really appreciative of what you've shared with us, although I must admit it is a little bit difficult when you refer to the different pieces of legislation and you didn't refer to the bills paragraphs, but I think I've been able to follow most of what you've been able to share with us. Thank you very much. Could I just ask, would the national department's representatives like to comment at this stage? I do know that you probably also saw the presentation for the first time. I don't know, Centre, did you present this in other provinces before? Ms. Midgley, are you going to respond? Or?
We haven't done a formal process, but we have submitted some written comments in KwaZulu-Natal's public participation process. But to my knowledge, the Western Cape was the first provincial public participation that we were able to.
I can also just add that we have presented to the National Assembly's Portfolio Committee on Environmental Affairs. I think that was in 2018 on a previous iteration of the NEMLA bill. But a number of these submissions were made there as well, with the department, some members of the department present.
Good. Thank you very much then. So if the National Department would like to respond at this stage, I do know that you've indicated that you would like until the end of next week to respond in writing, but are there any comments from the very strong team that you've sent to us today?
Thanks very much, Chair. I think maybe from my side, from an enforcement perspective, I would probably just like to make one or two comments, and then I'll obviously open it up to the rest of the team in relation to whether they would like to comment. You know, my comment, I think, is specifically in relation to...
Sorry, apologies. That is Ms. Craigie that's speaking, perhaps.
That is correct.
Because we can't see one another, perhaps, you know, I would like others just to introduce themselves, but you're free to continue. Please continue, Ms. Craigie.
Thank you very much. So the comment that I am making is specifically in relation to Section 24G. I think it is just important to understand with regard to, I think CER made a proposal to increase the fine from 5 million to 10 million rand. That is actually in the amendment already. So, you know, that is anticipated that we would be increasing that, and obviously that is to try and bring down the abuse. And maybe just the other thing that I thought I should just let the committee know about is that we have a national project actually looking into administrative penalties generally. So we've actually been running that project for almost a year now. We are getting a new discussion document from the consultants that are assisting us with that, and some of the work that CER did do was also used as a basis for some of that project. So I think just to let you know that there is a national project around administrative penalties, and is it something that we would like to incorporate into our environmental law? And obviously it is going to take a little bit of time still, but at some point that project would be brought through, I'm sure, to this committee so that you could see the outcome of that. So from my side, short and sweet, but let me open it up to my team to see whether they would like to also make comments on specific items within the legislation. And as you said, Chair, if the team could just introduce themselves before they speak.
Thank you. Who would like to respond next? I see the hand of, is it Vumile Senene?
Correct, Chair.
You're welcome to continue, sir.
Thank you very much, Chair, and greetings to honorable members as well as the stakeholders in attendance. The first response I'll provide is in relation to the advisory committee, whereby the current amendment proposes that this advisory committee be a discretion whereby minister can be able to actually establish this committee. The proposal currently is that it must remain a must. And so our response to that, Chair, and to the members is that in relation to equality management, we have many different specialized fields that are required for us to be able to address as we deal with equality legislations and policies. So to have a standing committee that doesn't have a specific purpose that it addresses may not be the ideal circumstance that we want. So what is being proposed is that the minister has the discretion as and when a need arises for her to establish this committee, which then will allow the minister to be able to identify the necessary skills needed to solve that particular problem. So we do propose, Chair, that it remains a may, so that we can be able to utilize the resources that we have appropriately and to target a specific challenge that we may have at hand. So that is the first part. The second part on the revoking of the AEL. We welcome that this particular clause is being welcomed. However, there is a concern that it may be too restrictive in terms of the additional steps that are needed for the licensing authority to take before they can actually finalize the revoking of the license. What we are saying, Chair, on this one is that in terms of the Promotion of Administrative Justice Act, it is required that the law must be procedurally fair and it must be lawful. So in a way, it is a requirement that the licensing authority, before revoking the license, they have to prove good cause, because not all offenses or non-compliances are equal in terms of their magnitude and the impact they may have. So in some instances, it can be that the company has failed to report over a specified period. That does not necessarily lead into the environment being impacted negatively. And so we say that these particular steps are in line with the principles of PAJA, where we have to take whatever administrative action that we have taken, it must be justifiable. So we are proposing, Chair, that those particular safeguards must be maintained so that the license holder is not negatively and unfairly impacted by a decision. Thanks, Chair. Those are the two that I've addressed.
Thank you, Mr. Senene. And the next hand that I recognize is that of Ms. Govender. Ms. Govender, are you going to comment on the Waste Act? I saw the hand of Ms. Govender. I don't know if you've lowered it again.
Sorry, I forgot to unmute myself. Yes, I will deal with the aspects relating to the Waste Act. If I may, there are three issues that I'd like to address. and everything else that has been raised by the Centre for Environmental Rights will be addressed in full detail on the written submissions. So I'd just like to deal with the register, the Contaminated Land Register, which the CER is asking that it be publicized on the website. It is and has been for the last year published under the South African Waste Information Centre, so that it is there, and that has a list of all the contaminated land in the country. In terms of that aspect, we will not include investigation areas in that process because, as the register states, it's contaminated land, and all investigations that have not been confirmed or not confirming the land to be contaminated and is still under investigation will not be put up on that website for various reasons, and we'll put that down in writing as well. But we also don't want to create a panic in terms of, for example, certain investigation areas result in the land actually being not contaminated, and hence does not require any remediation activities per se. And hence what we want to do is have the register only of contaminated land, and that land having to be remediated. The second aspect that I want to deal with is in arriving at a decision on whether the land is contaminated or not, depending on the waste stream or the contaminant itself, is varied. So it, for a particular chemical, might take 3 months to determine if the land is contaminated. However, there are certain contaminants and certain environmental conditions that can only be determined once you have seasonal data of those areas. So, what your water table, for example, is doing across different seasons to be able to determine the full extent of contamination. And that's why we do not have a time frame in the legislation on the site assessments being carried out. Like I said, some site assessments can be done very quickly because of the environmental aspects, and some take much longer to be able to get done. So putting in a 90-day time frame does not necessarily fully address the contamination or the areas of contamination, and could actually result in an incorrect assumption in terms of how, for example, how big the plume is, in which direction it's moving, and that aspect. So that is why we do not have that time frame, because it is specific to different types of contamination. And the final aspect that I want to talk about is in terms of the remediation orders and orders that we issue. I support the request by the CER to have this published on the South African Waste Information Centre, and in future we will be able to do that. However, it would be difficult for us to be able to also include the site assessment reports and remediation plans, etc., and that can still be obtained directly from the department through a PIA request. Thank you, Honourable Member.
Thank you, Ms. Govender. Any other responses? I do not see any hands from departmental officials. So then, members, it's over to you. If there are any questions for clarity that you would like to put to the Centre for Environmental Rights. If you could give me an indication by show of hands. If none, perhaps you wouldn't mind me then just kicking off, and perhaps some of you may then would like to add. I would just like to know, you used a very interesting term for me, and that is the term directional drilling. Now, I've got an idea of what is meant by directional drilling, But my first question would be, does that need a definition in the legislation, or is there already a definition on of the term directional drilling? Then the second one is the department didn't respond on your comments, and it was in terms of clause 51 of the bill, 27 of the relative legislation on whether the minister must or may establish a national air quality advisory committee. It seems to me as if at this point in time the legislation requires that as a must, and I would like to know actually from the department officials if they could just tell me or us, why would you shy away from the word must there? And then the second last one is, and I think Ms. Govender has responded to the 90 days limit for a site assessment. It was on your slide 15, Centre. But I can see the value in some form of time limit, or why this can't be left indefinitely. And if the 90 days is problematic, I would like to know, now that the site has heard that, that the centre has heard that 90 days may be problematic, would there be another wording perhaps whereby the site assessment could start, or, you know, just so that it's not an open and indefinite issue? And then the last one, we've heard that the Contaminated Land Register, that there is already such a register, but it then seems to me as if including the need for such a register in legislation is something which the National Department then would be open to, or that could be included in legislation to just confirm that there is such a need. So first over to the centre, and then perhaps to the National Department's officials again.
Should I step in and take some? Okay, great, thank you. Let me first respond on the air quality provisions. Just one comment that I suppose I wanted to make in relation to the spend and the fact that it might be unduly burdensome on licensing authorities to have to show evidence of environmental harm and health impacts. You'll see in our written comments, we say there that if that requirement is to remain in place, then I think there's room to at least change the wording to make it less burdensome. The requirement for evidence, I think, is quite problematic. You'll see that the Waste Act has similar provisions for revoking and suspending waste licenses, and the wording there is that the licensing authority, if the licensing authority is of the opinion that the non-compliance with the license or the act is having a harmful impact, then revoke or suspend. Less onerous, and that wording is already in the Waste Act. So changing evidence to requirement of an opinion. The other problem is the significant detrimental effect. I mean, what is a significant detrimental effect? So potentially just the word significant should come out. But again, I refer to our written comments, and we have no objection, of course, to procedurally fair process when it comes to the revocation and suspension of licenses. We support the fact that the bill provides for a process where the license holder is consulted and relevant organs of state are consulted. We, in our written comments, also suggest that there be a consultation process with interested and affected parties as well, before a license is suspended or revoked. So we're not saying that it mustn't be a procedurally fair process. We just think that requiring a licensing authority to have evidence of non-compliance with the Act or the license, in addition to having evidence of a significant detrimental effect, might result in licensing authorities not being able to properly exercise their power to revoke or suspend. Then in relation to the Waste Act, I wholeheartedly agree with you, Chairman. We aren't married to the 90-day timeframe. The point is that there needs to be a timeframe or some sort of obligatory requirement for having to conduct a site assessment within a reasonable period. Because you can't have a situation where it takes nearly 3 years to conduct a site assessment. So the point is taken, and we've had this discussion with the department previously about, if 90 days is too short, then make it 6 months or make it what it needs to be. But I don't think you can have a situation where there's just an open-ended amount of time, especially not a period that's longer than a year. And in practice, it took 2.5 years for ArcelorMittal to do their site assessment. In relation to the National Contaminated Land Register, I haven't found it on the SAWEC website, but I'm very happy if it is on there. I would appreciate it if we could get access to the link. But also just to say that it is extremely onerous and burdensome to have to constantly request these records and these reports and the site assessments and the remediation orders through PIA. It adds a very long time frame to a process where, in fact, you should be able to access this information in real time. About 5 years ago, we obtained the National Contaminated Land Register through a PIA request, and we were quite dismayed to see that at the time the register only reflected very few sites. Most of them were petrol stations, very few mines or big, large industrial polluting facilities were reflected on that register. I'd be interested to see what it looks like now. But yes, I was pleased to hear the department's comment about supporting the fact that that remediation orders should be publicly available, and I would implore the department to also add, the public availability of site assessment reports. And the assessments and the annual audit reports that generally have to be submitted as part of this process, just because there does need to be much more transparency when it comes to potentially significantly contaminated land. Thanks. I think I'll leave it at that.
Thank you. Thank you, Ms. Lawser. Any of your colleagues that would like to respond?
Yes, my apologies, Teresa.
Yes, with regards to directional drilling that is mentioned in regards to the NIMPA, that actually is not a definition that is provided in the NIMPA. However, it is applicable in the current proposed draft gas bill that I think is before Parliament as well, that has been sent out for consideration. That is an element that stems from there. And if we were to consider the application of the NIMPA, it's not only limited to the MPRDA, but it will also be applicable to the draft petroleum and gas bill as well. And it is currently applicable to as far as the MPRDA makes provision for gas exploration and extraction, as it is a combined bill, a combined act.
Thank you, Ms. Mugunyani. And Ms. Midgley, would you like to go last? You're on mute.
No questions for my provision. Thanks very much. We'll stay on the rest of the presentations.
You are most welcome, and thank you again for the work that you're doing, including obviously then presenting to us. But I presume that this is just a very small fragment of your daily task. So thank you very much for that.
Thank you so much.
We can now go over to the Department of Environmental Affairs and Development Planning. And I'm not sure who's going to do the presentation on behalf of the Western Cape Department. Mr. Mohammed, you said between Mr. Hardcastle and Ms. Rousseau. They will be sharing that. Would one of you be able to beam it up onto our screens?
Yes, good afternoon, Chairperson. Annick Rousseau. I'll be sharing it from my screen. Let's see. Can you see the presentation, Chairperson?
I only see myself at this point in
Okay.
time.
Let me just see here.
There we are.
Okay,
There we
excellent.
are.
Good afternoon, Chairperson. As Mr. Mohammed said, my name is Annick Rousseau. I'm with the Western Cape Department of Environmental Affairs and Development Planning, and together with my colleague, Mr. Paul Hardcastle, we will be presenting some of our comments on the NEMLA bill. So first, maybe just to start off with a little bit of background, we submitted as the Western Cape government comments on the first version of the bill that was published back in 2015. It was gazetted for public comment. Subsequently, we also engaged with our colleagues at the National Department and also in the various parliamentary processes. I think the CEO also mentioned the parliamentary hearings that were held in 2018, where we also did some presentations to the Standing Committee. Currently, the Western Cape government's comments on the bill, which is obviously the D version of the bill. So there's been quite a few changes since our initial comments in 2015. So our comments, we've basically divided it into three categories. So the first category is comments where we provide support for proposed provisions in the bill. Also, some of the provisions we don't support that are proposed in the bill. And then lastly, we also make some additional proposed amendments that aren't currently included in the bill. So those are the type of comments that we've included in our written submission. Today's presentation, we won't be able to go through all the comments we've made, but we will just aim to highlight some of the Western Cape government's key comments on the bill. So I'll start off with the presentation and then hand over to Mr. Hardcastle for some key issues that he will raise at the end of the presentation. So just perhaps to start off with a summary of the key comments that we'll be highlighting today. So given that the bill proposes amendments to NEMA as well as the specific Environmental Management Act, first off, just in terms of NEMA, we will be highlighting some comments on the definition of financial provision. First off, that the definition should not only be limited to the listed and specified activities. And then secondly, also, we would raise something on the definition of mitigation. Then secondly, in terms of NEMA, we'll be dealing with the provisions enabling financial provision, which is sections 24P and 24PA in the bill. And under those provisions, we just want to highlight that financial provision shouldn't be limited to only instances where they are prescribed through regulations, but it should also be allowed for the minister or an MEC to request or require financial provisioning in a specific situation. We'll also be making a comment on post-closure and that it should be defined. Then we will be proposing a new amendment, which is not currently included in the bill, requesting that there's a provision to enable the potential closure or lapsing of a 24G application. Then also in terms of NEMA, we'll be confirming our support for an existing proposed amendment in the bill with regard to the expansion of consultation through environmental assessment practitioners in terms of section 24.0 subsection 2, which requires consultation with state departments. We will also be confirming our support for the current proposed amendment in the bill dealing with section 31 capital D8, which deals with the consultation or interaction between the Minister of Environmental Affairs and the Minister responsible for mineral resources. But we'll also be suggesting an additional amendment to what's already being proposed in the bill. And then lastly, in terms of NEMA, we will just be touching on the competent authority and how the competent authority is identified with regard to activities related to national priorities. Then moving on to the National Environmental Management Air Quality Act, we'll only be highlighting one comment, which relates to the licensing authority for activities related to national priorities. We also propose that that provision should be reconsidered. And then lastly, we will touch on a comment that the CEO also raised as one of their first comments, which is on that Amendment Act 2008, which deals with mining, the relationship between mining, the older mining rights, and the current environmental authorizations in terms of NEMA. So I'm going to go into more detail on each of those comments now. So first of all, still under NEMA, the first comment we want to highlight is the proposed insertion of a provision allowing for the closure or lapsing of a Section 24G application. So just to confirm, Section 24G of NEMA deals with the consequences if someone has commenced unlawfully with an EIA listed or specified activity. And currently in NEMA, there is no provisional mechanism for the competent authority to either close an application that was submitted in terms of Section 24G or for the application to lapse after a certain period of time as a result of a 24G applicant not submitting information as required by the competent authority. So if the competent authority asks for information, it's not forthcoming from the applicant, there's no mechanism to close that application. And obviously the result is that you sit with pending applications with no final outcome. And this is problematic as there's no further action that the competent authority can take, and you're sitting with a pending application. And then sometimes this is obviously exacerbated by applicants that don't want to withdraw their applications. So these kind of remain open-ended. So we're proposing from an administrative perspective, for some kind of mechanism in NEMA to allow the competent authority to close these applications. And this is, we believe, crucial from both a contingent asset as well as a finalization of an application perspective. So therefore, we submit that a provision should be included to provide for the closure and the lapsing of a Section 24G application in an instance where an applicant fails to submit outstanding information as part of the process. Okay, then the second comment under NEMA that we want to highlight is it's a provision that's already included in the bill, and it deals with Section 24O subsection 2 of NEMA. So currently Section 24 capital O subsection 2 of NEMA requires that the Minister for Mineral Resources or an MEC must consult with every state department that administers a law relating to a matter affecting the environment. Now, what the bill proposes is to also include an environmental assessment practitioner to allow the EAP or environmental assessment practitioner to also fulfill this requirement. And we as a department support this provision. We support that the consultation requirement also be expanded and also be allowed to be done by the EAP. It's likely to shorten the process, make it less expensive, as you're kind of cutting out the middleman where the issues are directly related to the EAP, who will be required to address these issues in any way. We believe it constitutes good practice and it will contribute to reducing the risk of red tape reduction. Then the third issue under NEMA that I want to highlight deals with the identification of the competent authority for NEMA EIA listed activities that relate to so-called national priorities. So currently Section 24C of NEMA sets out the procedure to identify the relevant competent authority, which is either the national minister, so the national department, or the provincial MEC, who would be the provincial department responsible for environmental affairs. Generally, the MEC would be identified as the competent authority, unless, for example, I've only listed a couple, the activity has implications for international commitments, or it will go across more than one provincial boundary, then the minister would be the competent authority. Section 24C2 capital B, however, further provides that the minister must also be identified as the competent authority where a cabinet decision stipulates that the minister must be the competent authority for activities that are related to matters declared as a national priority. Section 24C of NEMA also allows the minister and MEC to agree that applications for environmental authorization may be dealt with by the minister or an MEC. So what this section 24C does is, even if the minister is identified as the competent authority, the minister and the MEC can still agree in writing that the MEC should, however, be the competent authority. This section 24C, however, currently in NEMA does not extend to the situation where Cabinet has identified an activity as related to a national priority. So the bill does propose the expansion of this potential agreement to also now include so-called national priorities, which we support. But I just want to also highlight why we had a problem with that and why we feel this section 24C should in fact be further amended. So first of all, why we feel it's problematic that the national department should be the competent authority for national priorities is, first of all, we support the principle of identifying national priorities, but we believe it's not the practical application of criteria determining when something is to be a national priority must be specific, transparent, and reasonable. The notion that only national government is competent to make decisions on matters declared national priorities is flawed. We believe often provinces are also best or good in a good position to make a decision on those activities. And then lastly, in terms of Schedule 4 of the Constitution, environment is a concurrent national and provincial competence. So as I've said, currently the bill, yes, it does propose allowing for potential agreement in terms of Section 24C3. Also now in instances where the minister is the competent authority for activities that are related to a national priority, which we support. And this is actually what is the crux of our comment. This is, however, not our preferred option. What we would prefer to see in terms of Section 24C is that Section 24C 2B of NEMA be deleted. And as I've said, that Section 24C 2B says a national priority would mean that the national minister is the competent authority. And what we would rather like to see is to use the existing Section 24C together with an agreed set of criteria to reach an agreement between the minister and the MEC in order for the minister to become the competent authority only in certain instances. So to not have this blanket, every time there's a national priority, the minister must be the competent authority, but to more on a case-by-case basis reach agreement when it's more appropriate for the minister to be the competent authority. We believe it's more appropriate and transparent mechanism to allocate national priority matters to the national minister only in specific cases, and we believe it's consistent with the principles of differentiation and subsidiarity. And then a related comment to the one I've just dealt with is in terms of the Air Quality Act. So similarly to Section 24C of NEMA, Section 36.5 of NEM-AQUA deals with the identification of the minister as the licensing authority when it's relevant application to national, so-called national priorities. So Section 36.8 of NEM-AQUA provides for, again, a possible agreement between the minister and the licensing authority or the MEC and the licensing authority regarding the identification of who is the licensing authority. Now, this possible agreement does not apply to matters where the minister is identified as the licensing authority. However, the bill does propose to remedy this by expanding the potential scope of the agreement to also now include this provision as well, which we do support. But just to perhaps highlight why the existing position is a challenge is, yes, although we support the concept of national priorities, as I've mentioned, the practical application must be specific, transparent, and reasonable. And what I mean with that is currently there's no specific criteria as to when something is declared as a national priority. And then secondly, again, as I've said with regard to 24C, the notion that only national government is competent to make decisions on national priority activities we believe is flawed. And again, to reiterate that Schedule 4 of the Constitution, air pollution is a municipal competence. So similarly with 24C, we definitely support the expansion of the bill to allow that the agreements in terms of Section 36.8 of NEM-AQUA can now also be reached between the minister and an MEC or a municipality if a matter is related to a national priority. Although we support this, it is similar to 24C, more of a second option for us. It's not the preferred solution, as it does not adequately acknowledge the constitutional allocation of air pollution as a municipal function. And similar to what I've asked for in terms of 24C of NEMA, our preferred option would be to delete section 36(5)C of NEM-AQUA, which provides that the minister is the licensing authority for national priorities, and as this will allow district and metropolitan municipalities to be the licensing authorities, even for matters of national priority, and then it will still allow the minister and a licensing authority to reach an agreement based on the facts of a specific application for the minister to become the licensing authority if it is in fact required for that specific application. I'm now going to hand over to Mr. Hardcastle for the remainder of the issues.
Thanks, Chair and members. Thank you. Sorry, I've got a bit of a cold and flu, so yeah. Okay, I'm going to talk about financial provisioning. And first of all, I think I should acknowledge that a lot of work has been done on not an easy subject, and that is financial provisioning. First of all, I think we must acknowledge that a huge amount of work has been done by the National Department on something that is not that easy and straightforward. Firstly, Clause 8 of the bill proposes a new Section 24P2 that the Minister or MEC may prescribe in instances for which financial provision must be determined and provided for listed and specified activities. Now, understanding is that the mention and the definition of prescribe in NEMA mean that it's done through regulations, gazetted regulations. And this for us is a little bit of a problem, and we propose that that provision be reconsidered, that it also allow for a competent authority to require an applicant to provide financial provisioning in relevant instances, despite there not being regulations in place. So this can be achieved through the simpler amendment of Section 24P3. That, and now I cannot see totally what is in here because it is behind the icon, where prescribed, and then we add, or where specifically required by the Minister of MEC, an applicant must provide financial provisioning. That we believe provide the relevant flexibility that even if there is not regulations in place, in a specific instance, it can still be required that somebody make financial provisioning. So yeah, that's the first one. And then there's the next slide. We want to look at Clause 1 and specifically draw the definition for financial provisioning. And this is, we're stating a problem, but we don't necessarily have a great solution to this problem. And normally we would like to be very clear on what we believe the solution is. But yeah, let me give the problem statement rather. That we believe that the definition and enabling provision mustn't be limited to listed and specified activities, and that especially the definition and section of 24P and 24PA should be amended to enable the requirement for financial provisioning to apply much broader than only listed and specified activities. And for the example that we can give and is that, for instance, where old mines that does not have an environmental authorization and which listed activities therefore is not applicable, if those mines change ownership or in any ownership, change of ownership in mines, then we want the financial provisioning to still be applicable on those change of ownership situations. And we want to know that we can apply the financial provisioning provisions wider than only the reference to specified and listed activities. Now, this is a mouthful, and we'll be very interested to see if National agree with this kind of challenge. And hopefully, if they do, we can collectively find a solution to this challenge. Again, this is really to find a solution to make sure that a lot of these mines that does not have adequate financial provisioning is actually catered for, and that we make sure that finances for rehabilitation and is actually catered for. Okay, and then the second is also in clause 1 is a definition of mitigate. Again, we believe that the definition of mitigation or mitigate is too narrow. And I think a lot of the time, a lot of the impact assessments that's being done is actually not acknowledging the mitigation hierarchy, which include avoidance as the first step. So if you can avoid an impact, you don't necessarily have to mitigate it. So we believe that if we improve on the definition for mitigation, that will assist us in actually following the steps of the mitigation hierarchy, and then we set the example, the provision there, or the amendment, to include avoidance, and then only thereafter mitigation, remediation, rehabilitation, and lastly also offsetting. But again, offsetting is the last step. It's not the first option that you have to consider. So yeah, that is what we propose in terms of the definitions. Then clause 8 inserts a new section 24P, which includes the phrase post-closure. And there's the provision, I'm not going to read it, but just reference to post-closure. And this relates to an issue that we're all well aware of, and that is that the legacy implications of mining inevitably becomes a societal concern. And asset mine drainage is a typical one where it's now becoming a societal concern because it's not adequately dealt with in the closure and the post-closure activities of mining companies. Here we find that post-closure activities or post-closure is not defined in NEMA or the draft financial provisioning regulations, and I stand to be corrected. But yeah, so the concern here is that what is meant by post-closure, and the real issue here is for how long after closure must an applicant be held responsible for providing the funding for rehabilitation, first of all, monitoring, and then if there is, in fact, then an impact, that impact be addressed and it doesn't become, it's not an externality or internalized by a community, or it becomes a community concern, in other words. So I think we need a bigger conversation of how do we define post-closure. Maybe the problem is not to define post-closure, but how do we deal with the issue of post-closure and how long and the extent of period that we consider post-closure to deal with. So yeah, that's also an issue that needs a lot of debate. Then it's a cooperation between authorities to take action, and that's clause 17F. Now in section 31D of subsection 4 to 9, it sets out detailed requirements and procedures for when the Department of Mineral Resources officials fail to perform a function related to compliance monitoring and enforcement, and how to deal with that situation. Now, an example here of is that in 2016, I think it's water affairs, environmental affairs, mineral resources, and our department formed a collective task team to deal with alleged unlawful activities of mineral sands along the West Coast. And we collectively then approached the court, and a magistrate issued a search warrant. And then just before on the day of the search, then DMR pulled out, and this resulted in the search warrant being set aside on review. And this and maybe other examples is why then it prompted the amendment of section 318D8. And it now reads that subsequent to subsection 7, the minister may, and they deleted in concurrence and put in after consultation with the Minister for Mineral Resources, within a reasonable time, then direct environmental management inspectors to do something. Now, obviously, the current proposed amendment removing the requirement for concurrency is supported. The amendment, however, inserts the need to consult with the Minister responsible for mineral energy mineral resources first. Ideally, we then propose that section 31D8 be amended further, and we put a proposal there that subsequent to subsection 7, and then we add, and in spite of subsection 4, the Minister, and then we delete may in concurrence with the Minister of Mineral Resources, and then we add must in reasonable period of time take where appropriate direct EMIs. Why we propose this amendment is that subsections 4 to 8 or 4 to 7 already set in place a quite detailed procedure which includes numerous other opportunities for consultation between the two ministers. In fact, subsection 7 again says that there must be consultation. But when we've reached the stage where subsection or a clause or subsection 8 must apply, then there should be no further consultation, because then we've really reached a dead end. And when we don't want to really rock up at the site and then no, first we have to go and consult again. We believe that when we reach the stage where subsection 8 apply, no need for concurrence should be in place. Okay, the next, then is also the last one, and this one was also highlighted by CER. Clause 82 proposes a new section 12 of the NEMA Amendment Act. In broad, and this is maybe oversimplifying it, is that when environmental authorization was obtained prior to 2014 for activities related to mining, and a mining approval was issued in terms of MPRDA, then such an EA would be deemed to fulfill the requirements of NEMA as it stands now. We obviously support this provision because it's the provision contains a very important qualification, and that is that you must have all these authorizations that were supposed to be in place, or if it was turned down, then this provision doesn't apply to you. But what is not clear is what is meant by meeting the requirements of this Act. And for quite a number of years, and CR also raised it, we don't want this to be interpreted to mean that we support the principle of converting an EMPR into an EA. And what we're saying is that the wording of clause 82 and even the objects of a bill is quite ambiguous and ambiguously drafted, and it doesn't eliminate the uncertainty. And we need to make sure that we are clear and we stand firm on the principle that you cannot convert an EMPR into an EA. Anik, you can go to the last slide, yeah? So, and again, that was confirmed in that same mineral sands resource case, where the court also took a very clear stance, is that there's a very clear difference between an EMPR and an EA. So whilst we will support the conversion of an EMPR in terms of the mining legislation to be deemed to be an EMPR in terms of the environmental legislation, you cannot simply, through the stroke of the pen, convert an EMPR in terms of a mining legislation to now be deemed to be an EA. The test is significantly different. And it's supposed to be different, do different things. So we quite stand firm on this point, and we want to make sure that the provision or the clause does not advocate that or be interpreted to mean this, and therefore we seek clarity on this. Thanks, Chair. I think that's everything from our side. Obviously, we couldn't deal with all of the comments we made, but I'm sure that you will consider and read all of those, and that will also be submitted to the National Department for their consideration. So yeah, over to you, and we're welcome to answer any questions of clarity.
Apologies for my silence. Thank you, Mr. Hardcastle, and before you, Ms. Rousseau. Again, can I ask whether there would be anyone from the National Department that would like to respond to this presentation? Ms. Craigie, have you got colleagues that you believe would like to just give us your views on the presentation?
Thank you, Chair. Yes, let me go again first, and then I'll open up to the colleagues. I think perhaps I can just deal with the issue around 24G, and I suppose the lapsing of the application. This particular comment, as far as I know, didn't come up through our various processes, you know, Working Group 4 and all the consultation processes. And I do know that there is a lapsing provision, for example, with regard to normal EIA applications. You know, 24G is a little bit different, and I suppose we'll need to just consult internally as to whether it would also make sense, because with 24G, the starting point already is an illegal activity. And so you've already committed an offense. And then what happens is voluntarily, you then have the opportunity to put in an application. And the authority then requires you to do certain things. And if you don't do those things, then the way in which we've practically dealt with it is that then there is no obligation on the authority to continue to process that application. And often what happens is it's when the fine is issued, then the fine is not paid. And we normally, at least within the National Department, in terms of our protocol, we would then write a final letter and tell them that if they don't pay that within a certain period, or they don't give information that we still require as part of the application within a certain period, that we will consider their files closed, and that file is then handed over back to the enforcement section. Because remember, as I said, this application is not a normal EIA application. It then goes back for enforcement action. So that's how it's practically been dealt with. And obviously there's no specified timeframes within the actual legislation itself. So I think we'd have to discuss a little bit around, you know, whether it makes sense to put a lapsing provision into the Act now, and whether it is an amendment that would require further consultation with the other competent authorities before we can do that. Or not. So I think, as I said, it's not something that's come up before, but we would have to just take some internal discussion on that. So perhaps let me leave it at that, and then allow my colleagues to take any other responses that they would like to take.
Thank you, Ms. Craigie. And I see the hand of Amanda van Reenen. Please go ahead.
Thank you, Chairperson Amanda van Renen, also from the National Department. I just wanted to respond to the comments in relation to Section 24C to B. I think I first want to confirm that there's really no intention to imply that only the National Department is competent to deal with national priority areas. I think it was specifically because we wanted to provide for some form of agreement to be reached in cases where it is justified and it makes more practical sense for the province to deal with the matter. And that is why we have put forward the proposed amendments to both this section and 24C3 to allow for an agreement in this regard. So I don't think we have a lot of room for movement in relation to taking out Section 24C to be completely as is suggested by the Western Cape Province, because I just checked the provision as it reads at the moment, and it currently refers to where a cabinet decision stipulates that the minister must be the competent authority. So I don't think there's really a lot of room for movement to suggest the deletion of the section, but we do take cognizance and we take note of the practicalities around these things, that national shouldn't in all events be the competent authority to deal with these aspects. So we would suggest that we stick to what is proposed there, but maybe just as a point of clarity that there was really no intention to suggest that provinces are not competent to do this.
Thank you. Dr. Fisher.
Thank you, Chair, and good afternoon, honourable members and stakeholders. I'm going to just touch on two of the issues. The one is on the financial provision and the definition of financial provision without regulation, and then also the broader ambit of financial provision to look at old mines. Firstly, in terms of the financial provision, one of the key things that industry always wants is policy certainty. So to have a situation where without any kind of procedure written up or without any certainty on which activities would attract a financial provision, it might lead to policy uncertainty, and it's always said to be it hampers business. So I think we would need to be very careful about identifying activities or allowing kind of an open-ended identification of activities without any kind of procedure or without any certainty on what kind of activities they're trying to get away from activities, but what other kinds of developments would be subjected to a financial provision. So just a caution on that one. And then the second comment on the financial provision and the broadening of the financial provision in terms of mining. Again, mining is a listed activity, so it would be possible to do that, and we would certainly have a look at that issue if we're given the opportunity. In terms of mitigate, the mitigate is really, the definition was really intended for mining activities, and there you've already given authorization to impact in terms of your environmental impact assessment, and you've identified the areas where you wouldn't want to impact, and in your EMPR you've already also identified the mitigation measures for impact. So it is almost, it's when you're remediating, you are then remediating the impacts that you have allowed through your process. So I think in terms of the mining definition, and maybe that's the problem, is that we actually need to identify what we mean, for which section we mean that mitigation, that closed idea of the mitigation. We should maybe identify that in order to get away from this concern that we're not doing the avoidance and the offsetting, because once you've given authorization for mining, the financial provision, the sections on the financial provision really are looking at the mitigation and no longer the avoidance or the offsetting. Chair, I think in terms of how long after closure the applicants would need to keep a financial provision, we've gone into quite a lot of detail in that, for that in the financial provision regulations. So I do think that the Western Cape could have a look at those and see if that is then adequately addressing their concerns. Chair, I think that's all I wanted to say right now, but we will certainly have a look at the comments very carefully and see how we can still incorporate some of the concerns. Thank you, Chairperson.
Thank you, Dr. Fisher, and thank you. I appreciate you also referring to the balance between ease of doing business and certainty, and then the provision, financial provision that we need so that it doesn't become a burden on the government as a whole or the society as a whole. Mr. Senene, you're next, and for one other reason, I feel more at liberty to ask you also to switch on your video. I didn't want to do it with the previous speakers because I was afraid I might be called sexist or something like that. So please, Mr. Senene, you have the floor, but if you could also switch on your video, you're most welcome.
I have done so, Chair.
Thank you.
And thank you very much for the opportunity to switch on the video as well. With regards to the clauses that were mentioned by my colleague from the province, she had indicated that with regards to Section 36(5) of the Equality Act, as it pertains to the licensing authorities, it's very similar to Section 24C of the NEMA itself, whereby it relates to who is the competent authority. So she had indicated that there is a request that national priorities should not necessarily be the competence of the minister only, but province should also be considered. So the same argument was being made with regards to licensing authorities, because in similar vein, minister then was to be the licensing authority for those that are deemed to be national priorities. So our response to that is that this particular function is closely related to the competent authority. And so that argument that has been raised in that space of Section 24C also applies to the Equality Act in terms of Section 36 of the Equality Act. So our proposal is that once that particular matter has been sorted in terms of Section 24C, then it becomes consequential to us in terms of the licensing authority. But the intent, again, similar to what my colleague Amanda has said, has never been to say that minister is the only person competent for national priorities. But if a cabinet deems a particular project to be a responsibility of minister, then we will take that cue as well from that instruction. So the two are intrinsically linked in terms of what the licensing function is and what the competent authority is for a specific project. Thanks, Chair.
Thank you, Mr. Senene. And with that, members, I want to give you an opportunity also, should you have any questions arising from either the presentation or from the responses by the departmental officials. Thank you. Honourable Bartman, you can go first.
Thank you, Chairperson. Just a majority clarity seeking questions from the Provincial Department. On page 1, the proposed amendment to Section 1 of the input that we received, it speaks that they want to change the wording Chapter 5 and include the wording this Act to Clause 1 for NEMA. And I just wanted to find out what the reason for that is. What is the impact of changing that particular one? And then to the National Department financial provision, the definition, I wanted to find out on what basis does the amount in terms of the financial provision gets reviewed over the years. How does one, for example, ascertain that the money now that one has in year 10 gets reviewed compared to the money you said in year 1 that you're going to use? And then page 2, clause 1, definition mitigate of the provincial proposals. You indicated there that the definition is too narrow. And I just want to find out, because you made another input regarding the definition of remediate on page 3, but that's based on your definition of mitigate being accepted. So I wanted to find out what your view was on the definition of remediate, if your definition of mitigate is not accepted. And then on page 3, clause 2 of the provincial submissions, you suggested that, quote, their participation in the sector must be promoted, quote, closed. And I just want to know what does that mean? Then page 4 of the provincial submission, clause 4C and D, regarding the proposed new sections 24C2B and 24C3, you speak there about a criteria that the national department should use to make a decision on the matter in bullet point number 2, I think. And I just want to find out what specific would you like to see in such criteria. And then on page 6 of the provincial submission, clause 5, section 24G I wanted to find out, I thought that this particular clause from the province was already submitted to the national department regarding the removal of the wording, if applicable, regarding the public participation applicable to a section 24G application. And I wanted to find out if the reason it's in here again is because it wasn't accepted on a national level. And then on page 7 of 23 of the provincial submission, the proposed amendment to 24G, the first block there, it speaks to section 22A of Namakwa, and that only an application in terms of that section is required, and that you want to prevent duplication of approvals. But I just want you to explain that a little bit further, because I thought that the NEMA section and the Namakwa section are two different ones, and that Namakwa refers specifically to air emissions. And then on that same page, proposed amendment section 24G1, you speak about the administrative fee compared to administrative fine, but I'm unclear where specifically in the amendment bill or the act that is. If you could maybe just clarify that for me, please. And then on page 10 of the submission, clause 8 and 9, referring to section 24P and 24PA, I wanted to just get clarity regarding the second paragraph. It speaks there regarding, also again regarding financial provision. And it speaks there at the end to say that this broad interpretation, i.e. not limited to mining and mining related activities, is supported. But it was my understanding that it was not supported previously. So I don't understand, is that assisting the original submission, or is that something new that you're referring to? And then page 11 of 23, clause 17, referring to section 31D, 3A of the Act, you referred to the national clause that where they want to put in with any applicable duty provided for in this Act, and you only asked for it to be reconsidered and redrafted to clarify the duties being referred to. But I wanted to find out if there is some indication from the provincial department whether they feel that specific duties should be included and what are those duties. Page 14 of 23, referring to clause 32C and 33. I just want clarity regarding that particular section, because I'm not too sure what that is referring to, that particular submission. And then on that same page, clause 30, referring to section 34E. I wanted to find out if there are diseases in animals regarding that section. How does one confirm? And how does one confirm, for example, if the animal is put down, that they were put down, for example, because they had a disease? So how is that proposal going to work? And let me just see here. And then page 17 of 23, regarding the proposed amendment 34, it speaks to Namakwa and the essential national standards for control of noise, and that the provincial and local spheres of government are bound by any prescribed national standards. But that section 34 does not make provision for the minister to draft noise control regulations. And then you go further saying consideration should be given to amending the MAQA to specifically allow for the drafting of national noise control regulations. And I just wanted to find out why you want it as a regulation and not as part of the Act. And I'll just see here quickly. Page 21 of 23 of the input, under the Waste Act proposals, you write there clause 61 referring to section 345, but I think that might have been a mistake from the provincial department. I think you meant clause 62 referring to section 34T5. So I just wanted to get clarity there, because I don't know where the clause 61 referring to section 34 is that you are referring to. And then page 22 of 23, the proposed amendment section 56 of the provincial input. You speak there relating to the financial controls and auditing of the Waste Bureau. But I just wanted to find out, I thought that the Waste Bureau is being phased out. Perhaps I'm incorrect. So I just wanted clarity regarding that. And then there's another section, I made a note here somewhere. If I can just find it quickly. It relates to the Local Government Systems Act. Sorry, let me just see if I can find this section now. So essentially, when we speak to it so long, there's a section where you ask that the NEMA and the Local Government Systems Act be aligned. But I thought that the Local Government Systems Act is being amended as we speak. So I just wanted to understand what the implications would be in this particular amendments if the Local Government Act is already being amended at the moment. Are they being aligned? Does it still need to come as an amendment in the Local Government Systems Act? Is it being amended in this Act? If I could just get clarity regarding that. Thank you, Chairperson.
Good. Thank you very much for that, Honourable Bartman. Are there any other members that would like to raise issues? None.
Chairperson, yes.
Yes, thank you, Honourable Heron.
Thanks, Chairperson. I have two questions just on 24G for both CER and DEDP and the department. I mean, I share CER's concerns around 24G and that it's open to abuse, and that some developers could and do sort of budget for the penalty and then go ahead with unauthorized activities because it's quicker and cheaper to do so. So, I mean, they're calling the CER is suggesting that 24G should be abolished altogether, and I'm just wondering if they have a proposal as to what should be in its place, or how the act or the amendment should read to deal with unauthorized activities, or if they're just simply relying on 24F. And then to the department, if they can just explain their call for a provision for 24G applications to lapse or to be closed. What is the impact if an application is not is not closed or doesn't lapse, does the submission of an application then suspend any kind of remedial action on the part of the department? And if an applicant then doesn't pursue the application, any action the department wants to take is also suspended. So I'm just trying to understand what is the impact currently of there being no provision for a lapsing or closing. Thank you.
Good. Thank you very much, Honourable Heron. Just three issues from my side. But then first, members, we must just get clarity. This meeting was scheduled to run until 4. We're already 5 minutes over time. I do hope that you will be able to stay with us for a few minutes longer. And then also Honourable Bartman, I'm not sure if Mr. Mohammed and his team has been able to keep up with the different references. Could I afterwards ask them to respond on what they feel they would be ready to respond immediately? But would you be happy if Mr. Mohammed and his team provide us with written responses on those that, they may not be able to deal with in the limited time? Because I wouldn't like us to run over 4:30, if I could ask members and our guests if you would allow us that extra half an hour. Thank you. Just from my side, the first one was just, and I'm glad the Centre is still on here, and I trust that Selga is also on here, and I do know Selga came as observers and not as active participants, but one of the issues raised by the Centre was the issue of whether the power should be delegated to just the council or whether the words executive mayor, etc., should be included. My interpretation is that each municipality can determine its own set of delegations and what it wants to delegate to an executive mayor. But perhaps if we could just get some comment on that issue while you are all still part of this meeting. Then secondly, on slide 6 of the provincial department, there where you, I think it's you that wanted to include also the environmental practitioner. Perhaps you could just quickly throw up or beam up your presentation to consult with every organ of state. Perhaps if you could just help me with the word consult, because I'm envisaged that in some instances, some organs of state may not be quite as responsive as one would like them to be. And is that situation covered for where perhaps you want to consult, you inform, but you're not getting any response? Also, the whole issue of air pollution being a municipal competence in terms of the constitution. But then I also realized that some of our particularly smaller municipalities may not be able to venture into such a complicated, or I presume complicated, field such as air pollution. Perhaps if you could just share with us your thoughts in that regard. And then last one, the whole issue of financial provision. And I'm grateful that I think it was Dr. Fisher that responded on that one. Now, at this point in time, it seems to me it's more directed at mines and mining. But then from the province's side, it seems to me you also envisage other situations where you would also like financial provision to be included. But then taking into account Dr. Fisher's remarks that, we need certainty and, we can't have unfettered powers. What would be specific cases that where you believe the legislation should also provide for? Thank you. So I wonder, could I just ask the Selga? As I've said, I don't want to put you on the spot. If you would like perhaps to respond in writing afterwards or so. But the whole issue of the centre referring not only to the municipal council, but would like the executive mayor to be included in there as well. I wonder, is it Ms. Harigobin that would like to respond?
Thank you, Chairperson. Thanks, Chairperson, for acknowledging the capacity in which I'm here today. I will request if we could send you that response in writing, and I'll give you a 2-day time period. Is that fine?
Thank you very much.
Thank you.
We appreciate your willingness to assist. Thank you very much. As I've said, I don't think that is really why you came here to get some work, but I appreciate your willingness to assist us in that regard. Thank you. Can I now hand back then first to the Provincial Department?
Chair Paul Hardcastle here. Yeah, first of all, I think that we would definitely like to, Member Bartman, please, if you can dot down all of those sections that because I could not keep up on all of your questions. You obviously read our submission in detail, and I thank you for that. But we will really like to respond, and I'm afraid I'm not going to do justice now in responding to everything. Even if we can have a copy of the recording, so that we can make sure that we respond to all of the questions. I'm just going to mention a number of issues, and that's dealing with what the members have raised, as well as maybe in the national governments. First of all, just 24G. I think the issue here is that currently there isn't any enabling provision to close applications, according to us. And that's what we want clarity, is that you cannot have this open-ended application that lives on forever. And in fact, also in audits, you're saying, you know what, you've got a contingent asset, but you're not realizing it. So we just want more clarity on that, and that we can have an enabling provision that we close down those applications. That does not mean that we are not going to continue to take maybe legal action in certain instances. It is just simply to administrative prudence that you can deal with finalizing an application or closing down an application. Then just in terms of maybe then also I just wanted to say then yeah, the implication of not lapsing is Member Heron's comment. Yes, it is just simply we don't want to sit with 20, 30, 40, 50 applications on the books and they're all as open. We don't know where we are. We don't know to what extent it's going to be finalized, and it's taking a lot of administrative actions and capacity to try to resolve these applications, and we need to want to finalize that. But that doesn't mean that we are going to take other actions. But we don't want to keep on answering questions in terms of why these applications isn't being finalized. And I think maybe Ayub Mohammed can also deal with this question. Then just quickly also in terms of provinces not being competent, yes, that is, and maybe it's again, all what we're saying is that the default position, especially in terms of Section 36 of NEM Aqua, where the municipality should, and we're not talking about local municipalities, we're talking about district municipalities and metros, should by default be the competent authority, and in instances where they agree not to deal with it or cannot deal with it, then it obviously needs to be bumped up. But more importantly, and this we've mentioned to SALGA, there is quite a significant income that is now not going to a local authority in terms of dealing with these. The application fees for NEM Aqua applications, for ELA applications, is quite substantial. Yet these local authorities need to deal with all of the issues and the complaints at the local level, yet and even review the applications, but so it's also an issue about income that is not going their way at this moment in time. And we believe that the default position should be that provinces or national should act, provinces or in a case of air quality matters should be the competent authority, and we can use cooperative governance and a set of criteria, and that criteria can still be determined about when should we actually now change the competency, a competent authority for a specific application. then I think we'll come back to the issue about the definition of mitigation, and also then how that will impact on the definition of remediation. I do hear Dr. Fisher's comment on where mitigation was referred to. It was referred to actually after the assessment, after the fact, when it in dealing with mitigation and dealing with financial provisioning and rehabilitation. So we will look at that also in the meantime, certainly. In terms of the issue about policy certainty, I don't think it's so much an issue about policy certainty. Currently, the competent authorities has got quite a wide power in terms of what conditions they set for environmental authorizations, and we believe that you can anyway set certain requirements for financial provisioning as part of your conditions. So I don't think it's as much an issue about policy clarity. In fact, policy clarity is equally needed in terms of that when somebody, an applicant, needs to deal with mitigation and it's going to cost money, that there's adequate financial provisioning. I think it's more of a need that you can apply financial provisioning to both mining and the non-mining dispensation. And that's coming to your question also, and that is that, yes, 24P deals with wider than only mining. Previously, it was written just as mining virtually, but now they've got a section 24P as well as a section 24PA. Section 24PA is now specifically for the mining dispensation, whereas 24P is wider and it includes all listed and specified activities. And we support that because that is consistent with what we believe it needs to be. But we just believe that you don't have to use the financial provisioning only if there's regulations in place. You should be able to use it now already, consistent with the wide powers that a competent authority actually have, and more importantly, the urgent need that financial provisioning for other sectors beyond mining is equally needed. So for me, that is quite an important one. Then I think I'm not going to highlight any other issues at this moment in time because we simply don't. Oh, maybe just the issue about EAPs to be consulted. This is a practical issue. When you compile a scoping of an EIA report as an EAP, you need to make sure that you tackle all the issues. But if you cannot consult as an EAP with another organ of state, they may raise in their comments to the competent authority issues that you haven't picked up in your scoping or EIA report. Now that now creates another loop where the authority, the competent authority now say, I've raised, this issue was raised by another authority, I refer this back to you, EAP, you must address this, and that may have an implication of changing the report. So all we're doing is saying this is a very practical practical way of dealing with streamlining the EIA process. It's not trying to do away, and this certainly doesn't take away the need for competent authorities to consult during decision making. Maybe that's all I want to say. I don't know if my colleagues want to add something, but I know that we don't have time.
Thank you, and thank you for recognizing the time pressures as well. And I'm certain that you would have access to the recording. I know Honourable Bartman will, in all probability, not be able to list all the issues that she ran through, but I do hope that you would get hold of the recording and respond in that regard. Are there any, Mr. Hardcastle ended off by inviting his colleagues, if they would like to respond now. I don't see any hands. Good. And then can I ask, is there any other guest that would like to bring something, representatives from either the National Department or the Centre that would like to bring something under our attention at this point in time?
Yes, Honourable van der Westhuizen, I would just respond to the question of Section 24G and why we insist that it should not be applicable. Per the submissions that we have made available to you on page 5 of those submissions, we indicate our understanding of this section as having been a transitionary provision that had been made, and it was envisaged as a kind of amnesty provision following the commencement of NEMA. But we've seen that over the years, since the inception of NEMA, and that has been 16 years now, is that it has morphed into a frequently abused and budgeted for section by developers. And if we are to look at where we currently are with the NEMA Act and the NEMA principles, there is no need for Section 24G to be made available to developers, as if you are to bring an application in terms of NEMA, and if you are to wait for authorization and compliance to be given and licenses to be issued, there would not be a need to make provision for Section 24G. What this creates, and the perception that is created out of this Section 24G, is developers can budget for the 5 million fine and 10 million in this instance, as is what is being proposed, and commence development or any other activities before licenses are issued under the guise that they can make and they have budgeted for that 5 million fine. But should then that not be a provision that is made available, there would be a need to ensure that all licenses have been issued and are complied with, and obviously then Section 24F becomes applicable. However, if there is a need for us to maybe make a supplementary provision in terms of if 24G is not to be allowed, what will be the counter alternative? We can obviously then write such submission and make it available after this discussion.
Thank you, Ms. Mugunyani. And thank you very much again to all our guests, and especially for the work that you've put in to prepare for this session. I would like the committee now to go over for the last 8 minutes just to some internal aspects, discussing the way forward, as well as also the approval of the minutes of our last meeting. But again, from my side, and I believe I speak on behalf of all the members of the committee, to the centre, to the national department, to the provincial department, also SALGA, really, we appreciate your input. We appreciate your support in helping us in formulating our response from the Western Cape Provincial Parliament. And I wish you all a wonderful day. And with that, the discussion on this topic for now is closed, and we will be concentrating on procedure. So you're welcome to stay on. You're also welcome to exit the meeting if you so wish. Thank you very much. To the honourable members, we were, we are scheduled to debate the bill next week and Tuesday. But the National Department has indicated that they would like until the end of next week in order to prepare their submissions or their comments on the written submissions that we have received. And I think it would be very difficult for us to continue with our deliberations and formulating of our mandate without first getting the responses from the National Department on the submissions. Then also, I know that a number of us, myself, Honourable Maseko and Honourable Maran, and welcome to Honourable Maseko and Honourable Maran, who joined us just after we started at 2 o'clock, have been invited on an oversight visit next week, Monday, Tuesday, and Wednesday. So I would therefore like to postpone the discussion until a later date. And if it's fine with the members, then we will not be meeting next week and Tuesday for the reason or reasons that I've put forward. I trust that is in order with you. In the meantime, can I also ask our procedural officer just to beam the minutes of the previous meeting onto our screen? That was the meeting of the 28th of July, so that we can hopefully deal with that before the end of this meeting, and we have about 5 minutes left on the extended time, and I'm grateful for you.
There we go, Chairperson, the minutes.
Thank you. Thank you very much. Honourable members, please peruse the attendance register for that meeting and the apologies that we've received. Thank you. Then, after the attendance register, this was the briefing by Cape Nature on the submission for the norms and standards in the management of elephants. And the resolutions, you see that under paragraph 3. Good. And then I think at that meeting we also considered the minutes of the 14th and the 24th of July. And then, as I've said, we adopted the program, which we've just now changed somewhat. I can just tell you that in terms of programming, our intended visit to the Oeverstrand area on the 1st and the 2nd of September is still continuing. And thank you to those members who already indicated last week and since then regarding their availability and also their preference to travel with official transport or private transport. So with that, honourable members, I therefore put the minutes for consideration. Are there any comments on the minutes?
Move to support, Chair. Deirdre Bartman.
Thank you, Honourable Bartman. Is that
move to
unanimous?
second, Chair Matlodi Maseko.
Thank you, Honourable Maseko. So that our minutes have been adopted. Can I just ask honourable members, are there any specific resolutions that flow out of today's presentations? Or can I take it that at our next meeting, we will by then have all the written input, also responses from the department? And I trust that our legal advisor will then also be able to assist us in our deliberations. Is that fine with you, Honourable Bartman?
That is in order, Chairperson.
I see your hand.
I wanted to find out in the provincial submission, there are some clauses where they disagree with the national department and the proposed wording was suggested, but then there are other inputs that they made regarding sections and clauses they disagree with where the proposed wording is not proposed. Can we ask where they disagree and have not put an alternative or an amendment wording that they could suggest what the alternative is? Because otherwise it's just us on those sections essentially complaining about the particular sections. Thank you.
Thank you very much for that, Honourable Bartman. I absolutely agree with you that where there's an alternative wording required or proposed, that we need that, and that we need that, I almost want to say in legal language, formulated as an alternative for us to send through, possibly send through to the NCOP. Ms. Niekerk, would that be in order? Would you be able to communicate that with our provincial department?
That's fine, Chairperson. I shall do so.
Thank you very much. Honourable members, if there's no other business, and I don't see any hands, I want to say thank you very much. I appreciate also you staying on for an additional half an hour. As you can see, this is quite a complicated bill, which is addressing quite a number of pieces of legislation, which I think for many of us is quite new. And therefore, I really appreciate also the work that you will put in studying that bill together with its original legislation that it's referring to, that it wants to amend. And I refer you also to the folder in Teams where Ms. Niekerk has uploaded the various pieces of legislation, but particularly the document that she sent out yesterday morning around about 9 o'clock or 9:15, where she dealt with the submissions on a clause-by-clause basis. I think that will be of great assistance, and I want to thank her again for that. And members, with that, I say thank you and go well, be safe, and be healthy. The meeting is adjourned.
Thank you, Chair.
Thank you.
Thank you.
Thank you.